This is, by the way, a non-calendar case. The arguments are 15 minutes aside. You have the first 2 minutes without interruption.
Thank you, Your Honor. Mr. Chief Justice, Associate Justices, I'm Charles F. Justine on behalf of the people. There are 3 reasons to reverse the Court of Appeals. First, they're wrong in the interpretation of the statute. Second, based on the facts known to the officers at the inception of the stop, although a mistake of fact, was objectively reasonable. And third, if this court disagrees with our interpretation of the statute, it was an objectively reasonable mistake of law on the part of the deputies. As to the first point, the statute requires 3 things. First, the plate must be securely fastened in a horizontal position so as to prevent it from swinging. Second, the plate must be attached at a height of not less than 12 inches from the ground, measured from the bottom of the plate, in a place and position that is clearly visible. And third, that the plate must be maintained free from foreign materials that obscure or partially obscure the registration information and in a clearly legible condition. When you read these 3 requirements together, the legislature's intent is that the plate is capable of being read. The trial court found that it wasn't capable of being read because the lower half of a digit was covered up by a hitch ball, and therefore the stop was valid. The officers, when they were looking at it, thought it was a 5, so they inputted a 5, and it came back to an Equinox, 2007 Equinox, which was not a Chevrolet pickup truck. As a consequence, they stopped the vehicle. That's an objectively reasonable statement of, or indication of the facts on the part of the officer to justify the stop. Under the recent U.S. Supreme Court case, Payne versus North Carolina, it was also an objectively reasonable mistake of law if this court disagrees with our interpretation. There are 2 corrections.
Let me ask you a question. It's time now, right?
Yeah.
Does it matter that the officers ran the plate and it came back an Equinox when what they had in front of them was a Ford Ranger? Is that essential, or is it sufficient that they just couldn't read the plate and therefore they could make the stop?
I think either position supports the stop. I think first...
Either one you think is sufficient, standing alone?
Right, and what was nice about this was the trial court recognized that very issue and talked about that during the hearing. I think the trial court spent a great deal of time at the motion hearing on this very issue. I think it was interesting that Deputy Ottinger indicated that, well, yeah, we thought it was a 5. We deliberately put in a 5. It turned out it was a 6. We found out later. But we also stopped it because of the obstruction. So he was very honest about that, about the reasoning behind it, because they knew they either had the wrong plate on a vehicle or they had to let the motorist know that your hitch is blocking the plate, or at least one of the digits on the plate.
Counsel, can I ask you, what should a court such as this one do about what I'll call the illegalization problem? Namely, that if the penultimate sentence, which focuses on clearly visible, is given what some might argue is its ordinary meaning, namely that the plate has to be clearly visible on the part of police or pedestrians or others who see some wrongdoing, at least from a rear view position. Mm-hmm. And to read it that way would immediately render illegal, I don't know how many thousands of license plates in this state that have hitch balls or bicycle racks or things of that sort. Should that be simply something that's outside of our bailiwick and it's up to the legislature, or should we take any kind of countenance?
I'll tell you what I'm not going to say. I'm not going to say it's prosecutor's discretion. No, seriously, Your Honor, I think that...
yeah, I mean that seriously, too. What should a court of law do in that circumstance?
Yeah, seriously, I think this is what the legislature wrote. It says this. We have circumstances where, for example, if I'm going out on my bicycle, I throw on a rack. You know, I now based on my knowledge of the law, would want to make sure my plate could be seen, so I'm not in
You might want to
violation.
use an after product to replace your plate so it's visible.
That's correct. Well, that, you know, if
But
it's
none of the
defaced at
hitch-mounted
all.
bike racks,
I'm sorry?
none of the hitch-mounted bike racks or trunk-mounted bike racks have such an after product. So, what Justice Markman's asking an important question. I mean, Michigan's a real recreational state. A lot of us transport our bikes over to places where we ride them. Does it matter that right away, all of those of us who have rear-mounted bike racks or hitch-mounted bike racks are gonna be in violation of the law? If you
Well,
win,
if you don't put your plate in a position and place where it's visibly,
yes.
clearly visible, the answer is yes, that would be correct.
Otherwise,
oh.
bank robbers would attach bike racks to the back of their vehicles, the getaway vehicle?
Yes, I would think that would be one. I think the more clear thing would just hang a bandana over it, because based on the Court of Appeals reasoning, that would be okay as well.
But counsel, going to visible versus legible and just expanding on the questions that have been asked, let's take aside bike racks. What about just certain manufacturing issues that come out? Is it now the responsibility of a new vehicle owner to make certain that if it's coming out of the manufacturer, that it's at the standard that would not render it illegal?
Well, I think that that was the dissent in that Wilmot case, where the judge felt that the plate was where the manufacturer said it should go. But the legislature didn't say that. The legislature wants it in a place and position that's clearly visible, which means you have to take out 2 screws and move the plate whenever you're going to probably haul something that otherwise wouldn't have a plate. For example, if you're pulling a boat or a trailer, that would have its own plate on it. And so I think, as Deputy Ottinger pointed out, that would be a circumstance where he would have a plate he could look at to confirm whether or not there was some legitimacy in the recreational purpose that was being used.
Is there any sense in which laws that are arguably in pari materia, this one, could be read to suggest that the legislature is aware of the prevalence, in particular, of hitches, because we have laws that acknowledge that trailers can be hitched to cars. So is there any way in which those kinds of laws that recognize that hitches are a common appurtenance to a car somehow require that this provision be read in light of that provision, and arguably, even though a hitch might make the license plate less visible, it nonetheless is countenanced and looked upon as something that's attachable to a car?
I don't think there's any ambiguity in the statute which would require pulling in other statutes to try to decide whether or not
You
something
don't
is
need an
appropriate.
ambiguity in order to look at statutes that are in pari materia. They're actually considered extensions of the instant statute, so they can be looked at without there being some prerequisite of an ambiguity.
Well, if that were the case here, then, as I indicated, those would be separately licensed so that there would be a means for checking the registration
When you're actually
information.
using the hitch as a hitch.
I'm sorry?
When you're actually using the hitch to
Correct.
Did you diagram the sentence, by the way?
I'm sorry?
I'm sorry.
Did I diagram the sentence?
Yeah.
Did
No.
you go to Catholic school or not, is what he's asking.
No.
Well, it looks to me, in my failed attempt.
Which sentence? The second sentence, I assume?
Yes, the plate shall be attached. Looks to me that in the place and a position that is clearly visible modifies shall be attached. And then plate is the subject.
Okay.
Apparently that doesn't make a lot of difference to you.
I don't think it does, because I think if the position
All
in
right,
place
never
is
mind.
visibly,
I'll go back.
so would the plate be.
I'll recede. Never mind, go ahead with your argument.
So, there are two, if there's another question,
Well, just counsel, I just, getting into the issue of vagueness and overbroad, when we're looking at the definition of legible versus visible, how do we look at it in a way that it's not overbroad?
I think that the
And
court
from what
can-
vantage point are we trying to determine? Is it a subjective or objective standard?
I think the court can look at the dictionary and determine what the definitions of those terms are. I think that other courts, we've referenced several other jurisdictions that have addressed this issue. Some have similar statutes, some statutes are not the same, that address the same issue. And I think that those definitions are,
But just hypothetical, let's say it's a snowstorm, you're driving and the snow is, you're on the road and the snow's starting to cover it up. I mean, I would imagine it's no longer legible because of the weather conditions. So at that point, if you're in like a difficult weather scenario, are you technically in violation at that point, would you say?
yes,
Okay.
yes. Do I like it? No, but I
Right.
would say yes.
No, I understand.
I have two updates to make to the brief. One is the Harris versus State case out of Florida. That was the Second District Court of Appeals. There's another Court of Appeals decision, Baker versus State, that rejects what Harris says, and that's the Harris cases which relied on by defendant. And then the second point is People versus Gayton, the Illinois Court of Appeals case. The Illinois Supreme Court has reversed the People versus Gayton case, but not because of the statute. It held that both the defendant and the prosecutor, the interpretations were reasonable, and therefore it applied the rule of lenity. But then it went on and held, based on Hain versus North Carolina, that the stop was objectively reasonable mistake of law, and therefore, because the officer's interpretation of the statute was reasonable, and therefore reversed the Court of Appeals and held that the stop was valid. I just want to make sure the court was updated on those two cases.
You wish to reserve some time?
Sure. Thank you, Your Honor.
Good morning, Justices. Michael Oakes on behalf of Charles Dunbar. To follow up with questions, as Justice Larson has put, does it matter that it came back a different vehicle? I think it does matter in the sense that, as the officers testified to, the knowledge that they had at the time was this was one of two digits. The officers testified that within one block, they ran the license plate and initiated a traffic stop on this vehicle when they knew that it was one of two digits, that the officers knew at the time when they ran it with a 5, it came back to 2007 Equinox registered out of Lansing. However, they knew in front of them they had a Ford Ranger. They knew at that point that that digit was a 6. The officer testified that he knew it was either a 5 or a 6. So at the time of conducting this seizure on Mr. Dunbar, they knew that the proper digit was a 6. And it's our position that they were not reasonable in not taking a second or two to move forward and rerun that digit as a 6. And following up with Justice Bernstein, great point. It's a difference between visible and legible, and going in along with Justice Young and saying the sentence, the structure of the sentence. The second sentence speaks towards the visibility. The plate must be visible. It's the difference between visible and legible. The legislature purposely placed visible in a position, legible in a position. In sitting here in front of your honors, you each have nameplates before you. They're all visible. However, it's a piece of metal below each plate. Light is reflecting off of those. As I was sitting back in the congregation, I couldn't read Justice Zara's first name because, not because the plate itself wasn't visible, because the plate was visible. And nothing specifically on that plate obscured it. However, I did have something preventing me from reading each alphabet on that nameplate.
But the plate has to be both visible and legible, right? And it wasn't visible here, right?
The place and position that plate is at needs to be visible. officers need to be able to identify where is this plate, is this a Michigan plate, is the plate visible? Then the third sentence go forward to say, as far as the plate condition, the condition of that plate must be legible. You must not attach any foreign materials to this plate, and that plate shall be kept in condition which is legible.
The place, at least the way I parse the sentence, is the plate has to be in a position that makes it clearly visible.
That's correct. And the plate was clearly visible. They knew where that plate was at. They were able to locate where on that vehicle a plate was bolted onto.
Okay?
In following up with Justice Markman, as stated, in saying that any tow ball would be in violation of this statute, essentially saying that an individual here in Michigan, for the most part, wouldn't be able to utilize our Great Lakes by towing a boat there.
I think I was asking opposing counsel how he addresses that very concern.
And he cannot. He stated that if you're towing a trailer, it would have its own plate to it. A trailer plate is a permanent plate for that particular trailer, no matter which vehicle is pulling it. So that trailer plate does not give any information as to the registration of the vehicle that is towing that plate.
So anytime I'm towing a boat or a trailer, you can't see the plate on my car. You can't read it. I'm in violation of the statute whenever I tow my boat or my trailer?
Our position, no, because in which case you haven't done anything as far as if you're pulling a boat or trailer, the place and position of your plate is visible as far as if they go to the side of the vehicle
Go to the side and see my plate, yep.
to see the plate. And again, in the numerous cases that has decided this, in which they said the officers acted reasonable, in looking at them, one, you didn't have two officers in the vehicle. Two, the officers in those cases either moved to the side to get a better view of the plate, ran a couple different scenarios of the plate. We don't have that situation here. To just sit and say that a tow ball on the back of a vehicle on a bumper renders a violation of the statute wouldn't take into consideration whether the officers were in an SUV. That
Go ahead, finish your point.
it wouldn't take into consideration if the officers were in an SUV that's set up higher. Wouldn't take into consideration if it was a helicopter beaming down to look at the plates of this.
Now I'll
vehicle.
interrupt you, now that you've gone to helicopter route. Do I understand your position to be that the statute really only addresses what's physically obstructing on the plate itself, such that if I were to put this box of tissues in front of the plate, it would be visible under your construction? Does your construction admit that this circumstance where the plate is in the height, et cetera, required, but you put something in front of it, it is nonetheless visible within the meaning of the
And
statute?
looking at the statute as a whole, if you was to place that tissue in front of that notepad, it's covering more than 50% of that notepad. Again, at some point,
There's no percentage of visibility specified here. It just says clearly visible.
clearly visible.
So now we introduce what visibility means, how much of it's visible? I thought your position was, and the Court of Appeals majority position was, that the construction was such that only things that were physically attached to the plate itself affected visibility, not whether it was in fact visible, because it was obstructed by something in front of it. Isn't that true?
That's true.
Is that your position?
Yes.
Anything further?
Nothing additional.
Thank you very much. Counsel, do you have any rebuttal?
Are there any questions?
No?
Okay. In answer to your question, Your Honor, it's a very difficult question,
Yeah.
and that's why you asked it, of course. Plates can be moved, 2 screws, so they can be placed in a position and place where they could be clearly visible, I think.
So whenever I tow my boat, I should move my plate up on my car so it's higher than my boat or
I s-
something?
To be safe from an aggressive deputy, maybe.
Do boat trailers have licenses on them? But they're not the car
It's just not my
trailer.
car license.
Yeah.
It's got, yeah, my boat has it, my boat trailer has a license, but,
But as I,
Tells you nothing about the vehicle.
right.
Exactly.
but as I also pointed out, the boat itself has its own plate.
Yeah, but that may not be
Still
her
doesn't,
boat.
yeah.
That's correct.
You wouldn't believe
That
the
is a-
boats I
that's
pick
a-
up and drive around. Constantly picking up boats and driving
It's
them around.
sad but true.
So my default argument,
So the question is, what is the answer if you got your license plate is ordinarily visible, but as soon as you attach something to it, a trailer or other thing, even though it's got its own license plate, the car license is obstructed, right?
correct.
Any
No,
SUV with a open back, you can't, where the tow ball is, you will never see it when you're towing your boat, I promise you.
Yes, you're
It's just-
probably correct.
Yeah, I know I
I'm
am.
not gonna disagree with you on
Yeah.
that.
Right,
But,
so we might all have said, well, come on, he could have taken off the tow ball.
Correct.
But how's Justice McCormick gonna pull her many boats?
Yeah, and all my neighbors'
She
boats.
just can't do it.
well,
All
she's
my
not gonna
friends'
pull it
boats.
with one of those tow bars because I think the bumper's
Well,
gonna come
yeah,
off.
yeah,
But
but the boat is gonna obstruct the license plate.
Every single time I tow
What,
it.
how does she avoid getting that civil infraction? Because she
Alright.
doesn't want it. How does she do it? What does she do?
Well, I was gonna say my default argument is what the Georgia Court of Appeals ruled in Worlds versus State, where it talks about bicycle frames and so forth, and says, but this is not a question that need to be answered here, although the General Assembly would be the proper body to clarify the point.
That's a good answer.
that's
We
not a
could
bad
say-
answer
We could say that
always.
if you only have the tow ball, you could have taken it out, and we don't have to address my boat problem, my
Right.
many boat problem.
Maybe those folks across the way there might.
Yeah, they might
be-
need to address it, though. Yeah.
It reminds me of that dead mouse question you asked me quite some time ago.
I've been trying
But
to
anyways.
get it. You have your-
I see a lot of things that I don't remember.
It's throwing that stuff back, I guess, like people's
All right, thank you
newspaper
very
articles.
much. The case
Thank
is
you, Your Honor.
submitted.
Thank you.
We'll take a break for lunch and return 1:45.